Honourable David Parker.
Mr Speaker, I intend to address two issues. The first being the ludicrous change at the last minute to those workplaces where employees are not entitled to a workplace representative. And the second is the inappropriate provisions relating to trials that have abrogated the civil liberties of New Zealanders in a way that has been criticised by the New Zealand Law Society. Sir, the first point, as has been said by prior speakers, the Royal Commission, the special consultative group that the government set up, and overseas practice all show that having worker representatives having a right to call for a formal process in their workplace is a fundamental ingredient of safe workplaces. We know that we've got a very poor record in New Zealand of serious injury and death, and we know that a core recommendation of the Royal Commission and the consultative group was that that be remedied by having workplace representatives. What are the media saying about these, the contortions that the National Party has put themselves through? I want to read from today's Dominion. All workplaces, irrespective of their size and the industry they're in, should be entitled to ask for a health and safety rep. Then they talk about the 20 staff person limit and the current definitions of what's high and low risk, and they say there's no logic to it. And some of the defences of the exemption for dairy, beef and cattle farmers have been ludicrous. As my colleague Enlise Galloway has already pointed out, the definition seems to be constructed deliberately so as to leave out dairy farming and cattle farming. And we know from evidence that I don't think is incontrovertible, no one's disagreed with it, that even those statistics are underrepresentative of the true rate of accidents on farms. So even if you take that into account, their ludicrous definition would be breached. And then the idea that these farms are some sort of hayseed, unsophisticated, small enterprise is just wrong. These are multi-million-dollar enterprises. Dairy farms, the cows will be 750 kilograms, 3/4 of a tonne, the weight of a small car, Mr Speaker, and as others have noted, no doubt, we have many quad bike accidents. We have electric fences, the means of powering those fences, electric boom gates on to move the cattle along. There's a lot of dangerous equipment on our farm, large irrigators, and we have itinerant workers and seasonal workers who are inexperienced coming to these risks every year. A lot of the staff are working in workplaces where the owner of the farm is not there. It's generally quite often a share milker or another contractor who's conducting the farming operation. These are large, multi-million-dollar organisations with high risks, and there's really no case for them to be exempted. And I think that's a woeful mistake in respect to this bill. Sir, I'm not going to say any more than that because I think those issues have been well covered by others. I do want to address in some detail the concerns of the Law Society, which I think have been somewhat brushed aside in respect of the process that was introduced at Select Committee. Now, we know that in respect of legislation that comes before this House, if there's something that infringes or potentially infringes civil liberties, the Attorney-General has to, under the New Zealand Bill of Rights Act, produce a Bill of Rights Act assessment of it, the BORA vet. That does not happen in respect of changes that are made at Select Committee or in supplementary order papers that are tabled in the House at committee stage. In this case, very late in the process, the government at Select Committee, after submissions had been called and had closed, introduced some changes in respect of the way in which trials would be conducted where there was classified security information involved. Mr Speaker, the Law Society wasn't told about it, the Council of Civil Liberties wasn't told about it, and they were surprised when they found out about it. There was no mention of it in the second reading speech from the Minister. There was no mention of it in the third reading speech today by anyone. There is a scant two-line reference to it in the Select Committee report back, and it doesn't actually describe the nature of what is being done. The Law Society wrote a letter to the Minister on the 21st of August complaining about it, and they noted that this was, in their opinion, a breach of the New Zealand Bill of Rights. And I want to remind the House that the Bill of Rights at section 25 says the minimum standards of criminal procedure include a right to a fair and public hearing by an independent and impartial court, the right to be present at trial, and that's abrogated in some circumstances by these provisions, and to present a defence, which is undermined by these provisions, and the right to examine the witnesses for the prosecution, all of which are absolutely basic rights set out in the Bill of Rights. In addition, Sir, in addition to that, sorry, I'll collect my thoughts. The Law Society points out that these provisions, which abrogate those rights, have been inserted without any public consultation, any right of submission, and no Boravet. Now, Mr. Speaker, it is true that there was a minor amendment to the wording that the Law Society had previously seen put in place by the executive, effectively, by supplementary order paper just yesterday or the day before here. But the effect of that is not to cure the problem. It's the legislation as amended is tortured to read. I have read it 10 times. I'm not sure what it means. I know I have spoken with Austin Forbes QC. He's read it a number of times and he can't make clear sense of it either. But what is clear is that the later parts of that schedule, which give instructions to the court to be able to hear certain types of evidence without the accused and without the accused lawyer hearing it or being present in court when it is given, those provisions have no meaning at all unless they apply sometimes. So the attorney cannot be correct. The Attorney General, when he implied to the media, or this is what the media took from his comments, that the change meant that these were no longer problematic. It can't be right because those provisions sometimes apply. Mr. Speaker, I know that Austin Forbes thinks that the effect of the change to Clause 1A of to Clause 1 of Schedule 2A is that effectively where you have a proceeding that involves classified security information, although it's not saying it in that section, the rest of that schedule applies. So it's not an exclusion of prosecutions from the rules in Schedule 2A, it's just saying that it is subject to the provisions of that schedule. Mr. Speaker, the Law Society make the point that the breadth of evidence that can be covered is far too wide. If you are going to have a truncation of the normal rights to a fair trial, you should do it as narrowly as possible. And I'm not even convinced that it's ever necessary in respect of a prosecution under a health and safety bill. But let's assume for the moment that it was, which I don't accept. Let's assume it is. You do it as narrowly as possible. The sorts of evidence or the sorts of information that comes within the definition of classified security information is far too wide and goes against the Law Commission's recommendation, which says that you should really, in these cases, only be dealing with matters of national security, and a distinction should be made between national security and broader notions of international relations or economic interests. And I agree. We haven't had the opportunity to have that discussion. This is very poor legislation, sir. For the attorney then to criticise the Law Society that they were somehow misinformed and they were getting it wrong is in my opinion, beyond the pale, and I don't think the attorney should have said those things, sir. This is an inappropriate breach of the Bill of Rights, of the ability of people to have a fair trial, and I don't think we in this Parliament have properly protected that fundamental interest. Sir, I also note that we've taken away from the court the general discretion to oversee this, You know, if it's dealt with under the Criminal Disclosure Act 2008, the court has the ability to actually say, well, the police might claim that should be confidential, but we don't agree. That jurisdiction of the court is being ousted. Mr. Speaker, it's wrong. It applies to the police, not just the SIS, not just the GSB. This is far too broad. It's wrong in principle, and I can't see how it can ever be justified in respect of a health and safety reform bill.
Dr. Pamjit Pama.
Mr.